We're going to get started with the next panel. This will be an interesting one. It's titled No to the Wall, but Yes to Infrastructure and Redeployment in Bonds.
Thank you again, everybody. We have a wonderful panel today, very interesting topics, with a lot to say. So before we go any further, I'm going to ask each panel member to introduce themselves. And we'll start from that end. Jeff.
Hi there, Jeff Drinkwater with NES Financial. We're a part financial services, part technology company based in San Jose out in Silicon Valley. And we have a host of solutions to help developers and the investor mitigate risk.
Thank you. Richard.
I'm Richard Booth. I am the EB5 compliance officer with Signature Bank, a full-service commercial bank located here in New York City. We are actually the largest bank in the EB5 banking space, and the only one in the United States with a compliance officer for the EB5.
Thank you. Kyler?
Kyler James, Vice President and Chief Economist for CMB Regional Centers. Operate a collection of regional centers across the country with over 5,000 investors.
I'm Kate Kalmakov. I head the EB5 practice at Greenberg Traurig. Greenberg Traurig is the largest law firm in the United States, and we have one of the largest EB5 practices nationally.
Thanks, Kate. Julia?
My name is Julia Park. I'm the Managing Director of AAEB5 Group, Advantage America EB5 Group. We operate 6 regional centers in the United States. Mostly our projects are located in New York City.
Thank you. All right, so this panel is entitled No to the Wall, but Yes to Infrastructure and Redeployment with a question mark. So, no to the wall. What do we mean here? Kyler, I'm going to start with you. No to the wall.
Sure, absolutely. For me, you know, sort of the idea of the wall, when you look at EB5 especially over the last few years, what we've found is that projects are coming into this, investors are coming into these projects, doing the best that they can, obeying the rules as best as they can, and 2 years into it, oh, we're going to change the rules. We're going to adjust things. We're going to put up, again, the wall. We're going to put up additional obstacles for you. We're going to create a scenario whereby you will fail. And redeployment's a great example. Projects that were structured 4 years ago, fully funded 2 years ago, have investors currently in them, are now looking at this saying, well, we didn't envision this. How do we restructure? How do we avoid this new obstacle that's been created? And how do we move that forward?
Right. So what you're saying, Kyler, is that we are building a wall. We're proponents of pro-immigration, and yet we're building a wall.
Absolutely. At the end of the day, the program doesn't exist to stop immigration. The program exists to bring immigrants into this country, to create new American jobs within this country. One of the previous panels, one of my colleagues suggested the idea that nobody has really put together a good economic model that looks at the economic impacts of bringing these high net worth, entrepreneurially minded immigrants into the U.S. What a fantastic thing that we have, and yet for whatever reason we've created this scenario where we say, let's stop immigration instead of act as the program for immigration services.
Yeah, but Kyler, don't you feel like the certain amount of compliances and a certain amount of rules are necessary?
Absolutely, and rules existed 2 years ago and 4 years ago, and those rules were obeyed, and now we're adding additional rules. We're adding additional obstacles.
And as a regional center, are you finding yourself, Julia, that banks are actually not helping, that they have too much compliance?
Of course not.
Well, Richard, you had the compliance. How are you making life harder for immigrants?
We are not making life harder for immigrants. We are making life safer for immigrants. We provide a very good framework for the EB5 space. Let's face the facts. The EB5 program has matured, and the numbers are larger than they ever have been, and compliance should be welcomed to ensure the survival of the program. We welcome the integrity provisions. We are a bank. It's in our DNA. And regional centers who are fighting the integrity provisions really should take a step back and look at the business that they're in. I mean, you're dealing with millions of dollars. And, these are things that banks, routinely deal with on a daily basis. We work with many regional centers across the country, and I've met with compliance officers of all across the U.S. And I'm always very happy to share what we do at Signature Bank in terms of the framework. We have built out robust compliance measures that go from a process assessment to a risk assessment. We have regulators that routinely look at our program. Matter of fact, we have 6 regulators in-house now from the FDIC that are going through the program as we speak. I have met with them on numerous occasions, explaining the intricacies of bringing investors in from China, bringing investors in from the Middle East, and we have done a very good job in terms of meeting what they expect.
Sorry, Richard, how much of the market share do you have? Does Signature Bank have of the EB5 market share, that is?
I don't know the exact percentage of that, but I know that we are if not the largest player, one of the largest players in the EB5 space. Somewhere north of about $16.5 billion in escrow.
That is a fair amount. Do you just accept any project into escrow, or do you have rules?
Absolutely not. We are very picky and choosy of the projects that we have in house, and that started long before I got there, and with our group director. But it was built out after my arrival at the bank as the dedicated compliance officer. And I'll just take a step back real quick. Fully understand my role at the bank, I report directly to the chief compliance officer. However, it was the group director at the program within the EB5 space who was the genesis of bringing myself on board, because he realized that the program was getting so big and realized that it needed to have an independent set of eyes looking at what's going on in this EB5 space.
Okay, thank you. Well, Kyla, you mentioned redeployment. Kate, what is redeployment for people who may not understand?
Sure. So redeployment is the concept of reusing the EB5 funds once they have been used for the EB5 purpose as described in the business plan and the PPM. And it's a relatively new concept that has arisen in the last year or two, because the wait line for China has grown so long that right now it's 10, 12 years for a green card. And according to the rules, funds can't be returned any earlier than, filing of the 829 petition. So if funds can't be returned, then they have to be used. And recently, USCIS issued new guidance with respect to redeployment, saying you must redeploy. So whereas before we may have held funds at the JCE level, which is your job creating enterprise or your project, now you have to redirect funds. You can't just hold them in an operating account. You were never permitted to redirect them back to the fund account where the investors are, limited partners or limited liability members, because then they wouldn't be considered to fulfill the at-risk part of the regulation.
Kate, it's not law yet, though. It's just a proposal.
That's right. It's just a proposal, but it causes, a lot of questions to come into play. First, what do we do, there's different models of regional centers. So where we have a developer-owned regional center that is using EB5 as financing for their developments, they presumably have a pipeline of projects, though not all may, and it's easy for them to redeploy. What do we do with the regional centers, though, however, that are structured to act as lenders that may not have another project right now? How would they redeploy? And if you're forced to redeploy, how do we safeguard investors' funds? Are we willy-nilly investing into any project because we have to stick funds somewhere? And so now what we're seeing in the market in response to this is the creation of different fund models where you can redirect funds and then they will choose different projects in which to invest them. But, USCIS, of course, hasn't adjudicated that either.
Right. Well, there's a lot of us practitioners who have argued against the redeployment rules as they are today. And I think the first thing we could argue is that redeployment is not necessary, because your funds do not have to be, by law, kept at risk at the I-29 stage. Julia?
So
It's the big wave. China market is dying. New funds, there's going to be a limited amount of funds coming in. The reality is there's billions and billions of Chinese investment already in the United States that's going to mature in the coming years. So the question really becomes what happens to those funds. It's a we can look at this question legally in two different ways. There is an at-risk requirement that people are talking about. EB5 funds to be at risk in the beginning of the process, in the I-526 process.
But not at the 829.
Not at the I-829 process. At the I-829 process, the only requirement is that the funds have been sustained. But that's also a little tricky because when we say the funds, when we look at the language of the regulation, it says that the funds have to be sustained during the conditional residency period, which is a 2-year period following the approval of the I-526 in a normal circumstance. Now, with the backlog of Chinese visas and the future backlog of Vietnamese, and then in about 3 years, the Indian visa, if we look at just China, there is this 8 to 10 year gap between the approval of the I-526 and the beginning of the conditional residency period. So we have to ask the question, was the legislative intent when they said the funds had to be sustained during the conditional residency, did they really mean 2 years?
Well, I think also that we have to remember that when when legislation was written many years ago, it took 2 months to get your 526, not 2 years.
And there's also a very real securities concern here that is just not being addressed. Because this wasn't in the original offering document, the investor never saw this as a risk when they agreed to the terms of the private placement memorandum. So if you then send a supplement saying, according to CIS guidance, we must now redeploy, that investor is going to have a right of rescission, which in turn will jeopardize their immigration, which they may not want to. So it's really putting them in a very unfair position, and that securities aspect is not being looked at all by USCIS.
I agree. Jeff, you have, I know NES, I haven't forgotten you, don't worry. I know NES really do have a whole program for redeployment. Have you thought of all of these issues?
Yeah, so what we did, we saw this coming a while ago.
Can you speak close to your mic?
Yeah, sorry. So we work with probably close to 600 projects and 20 billion in targeted capital. So we saw this coming down the road. So what we did is partnered with a company called Capital United. So they're a registered investment advisor. They're objective in this process, and that's a big part of this. Is if you're a GP or a member of that NCE, you need to be objective and look at this not just as a developer saying, "Great, free capital here. I'm going to redeploy it into my next project." So this platform, what they designed is a couple different options. One of them, as an example, is Greystone. Gives you the flexibility where CapU looks at it, gives an opinion, and then recommends what you should do with that redeployment money. And, it gives you liquidity within that where you can actually customize it to each investor of when their conditional residency is coming due.
But does the investor have any say as to what you do with their money?
Well, that's, again, they should, right?
Well,
and that's,
do they?
They actually should have to sign a consent form of where it's going.
All right, so you give your investors a consent form. Do you give them choices?
Again, CapU does. They give the NCE the choices, and then the NCE will ultimately make that decision. But the NCE needs to show that they're objective in this process.
Kate, you have an issue with that?
I have to think it through. I don't necessarily have an issue. I'm good friends with NES.
We all are.
I'm just thinking about the securities compliance concerns. So I think besides a consent form, you'd have to have material disclosures in the form of a supplement included so that they can determine if that's truly where they redeploy. And then what if they choose not to redeploy? What happens to that fund if you don't have unanimous consent?
Kyla, do CMB is exercise the right of redeployment?
Sure, and frankly, when we talk about redeployment, and this being a new thing, CMB has structured all of our partnerships from the beginning that there was a capability of the general partner to have those funds redeployed. Obviously, that comes with its own level of scrutiny and its own level of information that has to be provided to the limited partners, but certainly in any of this, it really comes down to a simple question: who's your daddy, right? The SEC has certain rules, the USCIS has certain rules. when those rules do not play fairly, when those rules do not comply with each other, what rule do you have to obey?
And that's a great question because CIS previously said we're going to cooperate with the SEC more. When we issue guidance or when we change policy positions, we're going to do it in consultation with the SEC. But in fact, there's no indication that that is happening.
I mean, basically there's this legal reality. I'm part of reality too, so how am I? But I'd like to propose a solution because this keeps going. This is a big topic, by the way, guys. Every single EB5 conference.
Before you do propose a solution, Julie, because I was going to ask that question of all, my issue is fine. If you have a project NES are covering and they're doing the right thing, CMB are doing the right thing, even Kate, some of your clients are asking you and doing the right thing. What about all those smaller projects?
Some, Mona, all.
What about all of those? What about those projects where they really don't have guidance and they just know they're allowed to redeploy? Aren't we asking for fraud?
Yeah, I would say that's the biggest conflict of interest right now is a developer sitting with a redeployment option. What do you think they're going to do? A developer that's sitting on $20 million that they're getting back. They're going to plow it right back into their next project. And you want to talk about consent? Where's the consent there?
Right.
They're taking now 2 bites of the apple at risk. They didn't sign up for that. They signed up for a green card for 5 years of risk. Not 10, not 2 different projects.
That's right. Richard?
We are all about disclosure. We feel that if you're investing in a project and you're going through redeployment, it needs to be spelled out clearly and very forthright in the original documents, and the investor has to be able to make the choice. Because if they don't make the choice, then it's at the end of the day, it's their money, and they should have the ultimate decision where it goes. And I agree with Jeff that taking 2 bites at the apple, with the same developer, you could run some serious risks with that. And I don't think the developer or the investor really saw this coming down the road when they originally signed up, unless it was fully disclosed.
And that's very different than the current situation because now when you structure, any project right now, you're working redeployment into the documents. But even then, you're in a bit of a bind because we can't list a specific project where the funds will be redeployed to. We can list categories. But what if they don't materialize? Because, real estate is a fluid thing. An opportunity today may not exist tomorrow. And what do we do with these funds? In what time period do they need to be redeployed? None of this is clear in the...
Well, that is, Kate, if they're being redeployed within real estate. If it's a project which has their own, it's a developer project, they will redeploy it within their own project. And they don't even have to show it's redeployment.
If they have one coming up, right?
Well, they could technically keep the money forever and just call it redeployment.
And then we will also run into the issue, what if today I have a project in New York and my next one is in LA? Is that permissible under the guidance? What are the limitations?
Right.
Not clear.
So... solutions.
Solution. We understand that the USCIS is limited by the language of the laws and the regs do say that the investment has to be sustained during the conditional residency period. So it's not the USCIS's fault that this is becoming a problem because, for better or for worse, that is how the language is written. Where the USCIS can make a difference is the fact that they're applying the at-risk requirement at the I-829 level as a matter of policy. This is something the USCIS has control over.
Right.
And if we shift that policy, the funds can be kept in a more secure operating account as people used to do when timing did run over. It's now that we're being forced to put this money at risk. And this is a policy position, which I think we can fix.
Right. And I think there was a fear at one point when the draft regulations came out, that could these funds from redeployment be put into some kind of infrastructure project, aka the wall? No comments?
IKEA had some good instructions. I don't think I saw that.
I think we saw a lot of different proposals in this respect because I think infrastructure is really a priority of this administration, or so they have stated.
Right. That's where I was going to.
There was a little bit of a bouncing around of introduction of an EB6 program where you can invest at perhaps a lower amount, but it would be used towards infrastructure and the wait lines wouldn't appear. That didn't move forward. And in talk of the proposed legislation, we have certainly seen this proposal of a set-aside towards infrastructure also introduced.
Right. I mean, the idea of putting money, redeployment money towards the wall is not something that we just dreamed up. It was the EB6 proposal which brought that to the forefront.
But even besides the wall, just in terms of finding financing for infrastructure is very difficult in this country. So there are many legislators that have pushed for that to be introduced into the new bill as a way to, finance our crumbling infrastructure.
All right, but this money also is very cheap money because the original money that was brought in had a cost to the developer. So does a developer feel that he has a right to keep this money because he's already spent X amount of money getting the money in the first place?
Yeah, and he doesn't have to pay the agent.
That's right, exactly.
So this is great newfound money to them, and it's unfortunate because the investor on the first go-around gets, 0.25%, let's call it. And now on this go-around, what does he get? I've heard varying amounts up to 2% or so in some new deals. But ultimately, the developer's looking at this as really cheap financing. Thank you, Hein.
So if Julia, if we don't succeed in convincing USCIS that the money is not at risk, do you have any other solution for redeployment purposes?
Well, I think there's a cottage industry already popping up with these redeployment solutions. And I'm a realist and a practical person. We are looking into that. We're looking into creating our own redeployment solution with other partners, for example. So this, unless we have some clear guidance in the coming years, this is going to be a whole new industry, which is not necessarily a bad thing. The only people losing out on this are the investors, really.
Right, but how would the panel feel if, when it comes to redeployment, it's not USCIS that actually adjudicate, but perhaps another government body, something like the Chamber of Commerce? Kate.
That would be interesting. We've had before proposals to involve the Department of Commerce in EB5 adjudications, and they've never materialized. I don't know, because I haven't dealt with commerce, what it's like to deal with them, but, presumably they would understand, some of the financial aspects of transactions more than USCIS.
Right. Kyla?
My one concern, again, would be you're just inserting another body into this to take a look at this and answer another set of questions, again, further on in the game at this point, after you've already established that you've met all of the requirements of USCIS.
But wouldn't you be inserting a body who had more specialized knowledge?
Certainly, as you do with securities in the SEC.
But that doesn't have knowledge of all the nuances here related to the reinvestment and, requirements of sustainment. So what's the learning curve? What would we see in terms of adjudication?
Right, and I think also given the varied amount of different types of projects, that probably would be a longer learning curve.
Yeah, I think that the challenging part here is that our clients are asking for more clarity from the USCIS. That's the one thing. We talk to them about these different options that they have through this platform, and they are at a standstill, and they're waiting. And one of the things I always hear is, thankfully, I don't have to redeploy for another year. All these other people in front of me are going to learn the hard lessons of what I'm going to need to do. And I think that's unfortunate for these folks that do have to redeploy sooner than later. And again, that's why our platform, we think, helps give them the flexibility of liquidity, preservation of capital, transparency, and some yield.
Yeah, but Kate, I don't know if you've actually seen this. We have got clients who've managed to, prior to the 829 approval, maybe they've had a hotel or a senior assisted living home, and they've sold their senior assisted living home or their hotel, and the 829s have still been adjudicated and approved.
Yeah, and I see nothing wrong with that scenario. I think as long as the funds don't flow back up to the new commercial enterprise, you're fine.
Well, I'd even go further than that. We have had funds flow back up to the new commercial enterprise and be redeployed from the new commercial enterprise at the discretion of the general partner, so that it's not a controlled by limited partner scenario.
So the bottom line for redeployment, Julia?
I think we need to rethink the current policy. Outside of that, only the investors are at risk.
Kate?
I agree. I think mandating redeployment as opposed to keeping funds at a JCE level is concerning, or another operating accounts where, you know, they're at risk of loss.
If I can add in there, the concept of disclosure, we've talked a lot about that being an upfront necessity for any of this, and yet USCIS has failed to disclose in a lot of this. USCIS has failed to give us the upfront information that would be necessary in order for us as regional centers, us as attorneys, and again, the most important people at the end of the day, the immigrant investors, to know the risks associated with this from day one.
Well, I think they have given us information. They've told us what they want to do, and that is redeploy.
If that was the extent of the information I was giving in my disclosures, though, I would be in serious securities concerns would be present there. So it has to be more than simply, we want you to do this.
Right, but most PPMs do have a clause which protects the developer and the project owner against changes in the law and policy changes.
Again, most vulnerable person in any of this is immigrant investor.
Right.
Absolutely.
Richard?
It's the common thread throughout this panel and also with the other panels is that we need from the USCIS clear and concise guidance, and what we're getting is as clear as mud, and it can't exist. You're dealing with it's an immigrant investor program. It's here to help people come to the United States who are going to invest a significant sum of money. And you're dealing with bankers and you're dealing with attorneys who in their trade are used to dealing with black and white. And until we get that from the organization that is supposedly overseeing this program, it's going to we're going to continue to sort of bump along down the road. So again, we need clear and concise guidance so we can communicate that to our clients, whether it's a bank or an attorney.
Yeah, my comment would be like waiting for USCIS for more clarity is going to be like waiting for Trump to stay off of Twitter. It's not happening. So absent of that, we need to do what's right by the investor. We have an opportunity here, which we haven't done in the past in this industry, is to do right by the investor.
Right. Well, I've given my opinion that I'm very against redeployment the way it stands. I think it's fraught with difficulties. But redeployment isn't just one area that we're building a wall. Julia, we have other areas where they're building a wall.
Are we talking about bridge financing now?
We are.
Okay. So
that was your cue.
This is fairly new. Let me just give you a 3-minute background on bridge financing. It's really relevant in real estate projects, for better or for worse. I think Mona said earlier that real estate has somehow hijacked EB5. Real estate is a big part of EB5. Real estate in metropolitan areas, mostly New York City, for example, EB5 is used as mezzanine financing. That for non-real estate people is positioned between the developer's equity, there's the EB5, and there's the senior bank loan. Now, what happened before 2013 was the USCIS required a clear nexus between the money and the job creation. So if a developer used bridge financing to proceed with the project and then later used EB5 to replace that bridge financing, the USCIS did not allow this. There was a policy shift over the years that we kind of felt in the air, but it was articulated in 2013 in the May 30 guidance memo, where the USCIS came out and said bridge finance, EB5 funds can be used to replace bridge financing if bridge financing was contemplated prior to the raise of the EB5 or the bridge financing was temporary. Yeah. Now, what is temporary? Anything expensive? We don't know what's temporary. Now, the problem here is that we are now seeing the pendulum shifting back, and this is very recent, I think past 3 to 6 months. Yeah. We are seeing a trickling of RFPs coming out of the USCIS questioning EB5 funds being used to replace bridge financing, and we're hearing things like, well, temporary means under 1 year. Some people have pushed back and said, well, it was if it was contemplated, since it's an or, contemplated or temporary, then shouldn't it be okay? The USCIS has not really talked about it until Tuesday of this week, where there was a stakeholders conference where the USCIS economists stated that we don't believe that was meant to be A or B, so even if it was contemplated, that could be a problem. Now, here's where this is becoming a problem. in real estate financing, the bank, which takes up about 70% of the capital stack, will not come in until all the other money is already there. So if we are not allowed to bridge EB5 financing, we can't secure bank financing. So in order to secure bank financing, you have to have the developer's equity and the EB5 bridged. In September of 2015, the USCIS has started putting out RFEs asking projects to show that senior financing is secured. So now we have these two different
Which contradicts
pushes.
each other.
Contradicts
yes.
each other
Yeah.
in that they want us to secure bridge senior financing, which means we have to get a bridge unless the EB5 financing is going like 10 investors a day.
Which by the very nature of EB5 doesn't.
Is not happening. And because the China marketplace is slowing down, the speed of financing EB5 is slowing down as well. So now we're kind of stuck in the middle. You're basically saying that if bridge financing can only be for a year, but we have to secure senior financing, all EB5 raises by definition then must be raised within a year. And then we also have the weird incentive of if your project is really, really delayed, so when you get that RFE, nothing has happened, you're actually okay because you haven't gone out and gotten your bridge financing yet. So we're in a difficult situation and we need a little bit of clarity here.
Right, Kate.
Well, I mean, I think it's a huge problem. I think procedurally, immigration is probably going to end up in court on this because, you know, they issued binding policy guidance in 2013 after having notice and comment period. Here, they issued new policy guidance this year. There was no notice and comment period, and they basically changed this policy on bridge loans. And it impacts projects that were filed before this was implemented. So you have an issue of, you know, changing the rules retroactively. In terms of what they're doing, it's very problematic because I don't think a bridge loan is defined as 1 year. I don't think that's what it is in the real estate industry. And our friends from the bank can also comment on this. So if we're getting these types of noise, I think you have to include a letter from a real estate lawyer, from a bank, confirming how they define a bridge. And, you know, prior to this, CIS approved, we had one deal where we went back 5 years where we could show intent to use EB5 and say that equity was contributed in contemplation that it would be taken out with EB5 and it was to be considered a bridge, and that was approved. So imposing this requirement is really not fair, and it's also arbitrary.
And capricious. You have to use the full legal language. Kyla?
No, for me, the idea of bridge financing, if nothing else, I feel that USCIS with a combination of a few other things, is really encouraging those poor projects, those projects that are likely to find delays. That they're doing this both with the idea of this bridge financing, that if you find yourself later on and you haven't actually inserted the bridge financing, you haven't moved forward, and you're getting the RFE, you're better off. Well, those are indications from a project due diligence and underwriting standpoint that cause great concern at that point. When you couple that with the idea of you have to have your senior financing in place at this point. USCIS has come back several times and with some of our projects and said you only showed a term sheet, show additional information to prove that the project is ready. Those are indications that a project should be moving, should be damn near complete by the time that you have an RFE.
But I think that's where the issue really is, Kyla, is that you know, actual real life and business and you know, immigration rules, there's a huge disconnect.
Certainly.
Mm-hmm. Richard?
You know, my group does a lot of bridge financing, and you know, when they start talking about terms of bridge financing, you know, how long is it? You know, what's the time spent, the time, you know, breadth of it? you really can't put a number on it. It depends on the individual project and on the individual client. So for an organization to come out and saying it's going to last for so many months or a year or whatever, it's totally disingenuous. Every project is unique, and every need for bridge financing is unique. And some last 6 months, some could go on as long as 3 or 4 years. And so again, for them to put a specific number on it is not the way to go.
Richard, but bridge financing isn't cheap, though. I know your bank has quite high charges when it comes to bridge financing.
Yes, it's not inexpensive, but again, it's a tool to get between 2 points, and it's used in very unique circumstances, and it helps get projects off the ground. So again, it's something that we do offer to our clients, and we are proud to be able to offer it.
Yeah, Bona, I would just add, going forward, for people that are doing projects, I think when you get in terms of bridge, the way EB5 should be used is to knock out bridge, and it eliminates that risk of the project actually being completed.
I think to that end, one sort of strategy that you can use in structuring new applications, because we're defining terms in an artificial world, is any equity that's put in, we can define that as a short-term bridge and then bring in EB5 to take that out, so that we can work in sort of some kind of flexibility and have a strategy to get the EB5 funds in outside of this limitation. I'd like to point out one other problem with this policy is that now they're requiring that any bridge money that comes in, it has to flow through the job creating exercise entity. So before, you could, simply pay off the bridge with the EB5 funds. It didn't have to flow through the JCE. Now it does. And that, of course, is also problematic, because that doesn't really always work in the real world.
Yeah. Julie, you had a comment?
I did. I was blanking out. Yes, but because of what Kate was just talking about, this was also discussed on Tuesday. But I would like to point out that this is not a full-blown tenant occupancy situation. What I mean is there are certain areas in EB5 where the USCIS one day says, we're not doing this anymore, or we're changing this, and it just affects everybody like a tsunami. Tenant occupancy was one of those things many years ago. On the source of funds side, last year, the whole indebtedness issue, it one day said, we had a stakeholders call, we're not allowing this anymore. The bridge financing thing, we're still in the initial stages. We're only hearing about a few handful of these NOIDs and RFEs, people pushing back. The USCIS articulated its position a little bit on Tuesday during the stakeholders call. I don't think we need to call this a policy yet. They're pushing back a little bit, and we're in dialogue, I think, through these events.
I think also there has to be a little guidance as to the amount of time you can keep bridge financing. I totally agree. I don't agree that it's 1 year, but I do think there has to be, you can't, otherwise,
parameters.
Right, some parameters, because some people or some projects just totally misuse
The May 30
this.
memo was very open-ended. It was inviting people to do fully funded projects and just kind of refinance. There were problems.
But the May 30 memo also recognized the business necessity of requiring some kind of bridge funding, as well as the fact that EB5 takes time to bring in.
Mm-hmm.
Wasn't that solved with early withdrawals?
Can you speak on the mic, please?
I guess we'll go to questions.
That's okay, Chaim. We were just waiting for your comment. Nope.
Now,
Yes.
I thought we solved the issue of bridge financing through early withdrawals.
Of the early release of the
especially
escrow.
for Signature Bank, you have plenty of money in your escrow accounts, so you're providing bridge financing with the money that you already have in your bank. Why is it more expensive? But that's a separate issue. I thought the problem was solved, the bridge financing, by allowing, and USCIS is 100% behind it, early withdrawals from the escrow account. Now almost 100% of the funds is withdrawn upon submitting of the I-526 petition. Why is this still an issue?
Because I think fundraising has slowed down, Chaim. Getting funds out of China used to take no time at all, and now it's regularly taking even the largest agents we work with 3-4 months per applicant just to wire the funds out because of the restrictions that were introduced in July.
But the bridge financing has begun only because it took so much time to get the petition approved.
Yes, you're correct.
Right.
So once it's in the escrow, and it pops out within 2 months after it being in escrow, upon submitting a I-526. I understand the issue is still there, but a lot of it has been solved.
No.
And the problem, and the problem with China is not a real problem. The problem with China is that most of regional centers are chasing EB5 investors in large cities in China using the largest migration agents. Pessimism seeks in. Why don't we go to second and third and fourth tier cities in China where people do not have a clue what EB5 is, and yet they still want to come to America? They still call America in China Meiguo, the beautiful land, in spite of what's happening in the White House.
You can't paint that whole solving of the bridge financing with the early release with the same brushstroke, because every deal is unique. And the release provisions are different for every deal. So to say that bridge finance or early releases were going to solve the bridge financing issue is not correct. It's
but then we should write the early release provisions similar in every project, the same.
Well, you can't. You can't. Yeah,
you can have no market advantage.
And it also doesn't help the projects that are already pending months and months. That relied on guidance that was then changed sua sponte.
Complicated, isn't it?
It's a complicated business.
Absolutely.
That's why it's interesting, I guess.
So do we have, we don't have too much time left, and we don't want to encroach into the time that we're waiting to hear the golden pearls of wisdom from USCIS. Payman, you have a question?
Is it question time?
It's question time.
Okay,
Chaim kind of started the question time.
Very good. Thank you.
That's okay.
Well, I guess this is going to be a litigator's bonanza coming up, and I'm referring mainly to the redeployment. But before, I was going to just float something that maybe the panel could address. But just one thing I wanted to kind of point out in terms of, I guess, from an investment industry's perspective. When the funds are raised for the first project, the general partner of the NCE is basically acting in a non-discretionary authority, right? So the investor is picking the actual project. They do the due diligence. They look at whatever the financials are. The investor consents to make that investment in that particular project, and the investment is made. And the general partner, of course, then manages that investment. But after that, if we're going to redeployment, the general partner can say anything in the operating agreement that they do whatever they want with the money, but now they have a discretionary authority, right? They are choosing on behalf of the investors to make an investment. So now we start getting into thin ice as far as the securities laws are concerned, right? Because they are acting as a manager of a blind pool. So that's something that obviously needs to be taken into consideration. I'm sure it doesn't apply in all cases, but in many, we are now getting into securities laws. But with regarding to solutions, and I agree with the panel that redeployment should not be a necessity, that's for sure. But for now, I also agree that we have it, and therefore we have to come up with solutions for it. So really what I want to kind of talk about, or for the panel to give comments, is that fiduciary obligation of the GP to the investors, right? So redeployment is going to happen whether it has to be in another project, whether it has to be into a third party's project, whether it is into a fund. That fiduciary responsibility now comes in to actually act on the investor's best interest. So immigration matters aside, we're now talking about investment, which really ought to be at market returns, right? The first one may have been done at a 0.25% return to the investor, but the subsequent investments, really, it's not in the best interest of the investor to be made at below market investments. And that goes to whether it's another project, whether it's another fund. So the obligation becomes to find an appropriate investment vehicle or investment project that returns, provides a market return to the investors. and therefore the fiduciary obligation. So do you have any comments on that?
I think, Payman, what you're trying to say is something that would be there in an ideal world. I think what we are trying to speak about is that in the ideal world doesn't really exist, and but for a handful of good projects and regional centres, etc. No, joking aside, the issue really is here that how do we prevent misuse of redeployment? Because the redeployment rules as they came out in the proposal are fraught with difficulties. And I think the rest of the panel agree.
Yeah, opaque. To say the least.
We would all love to know.
Yes.
No other comment too? No. Right, any other questions? Really? Professor? No? All right, so we'll just end with a couple of closing remarks. Yeah, EB5 is being challenged right now, and I know if I say to each of the panel members, what would you like to see as a solution to the challenge, they're all going to say visa numbers. But other than additional visa numbers, if I can start at the end, Jeff, what would you like to see? If you had a little magic wand and you could wish for anything.
It's consistent with a lot of the other panels. Is just more clarity from the USCIS, more consistency.
Richard?
I'd like to see some good integrity measures be brought forth in this new legislation, but I'd also like to see it clarified. I don't want any kind of fuzzy clarity provisions that are going to cause more confusion for all the players in this space. Again, it's there's some very good templates out there, both with FINRA and the other regulators that they could lean on, and I think that if they work closely, if everybody here in the industry reaches out to their elected officials and to the regulators and explains exactly what they need. We are the experts. The folks in Washington are not, and nobody knows the business better than we do. So I think that again, if we get clear and concise, provisions on the integrity, it will raise the bar for all the players, and we will have a better program to go forth with in the future.
Kyla.
It's really the idea of TEA, investment levels, more visas, all of that. Absolutely.
You had one wish, Kyla. You can't have three.
Life would be my wish. Give us a long-term extension to the program. That's really what is killing the program at the end of the day, is the fact that we are all stopping and starting over and over and over again every 4 months.
Kate?
I also have a long list, Mona. But I guess it's a consistency in adjudication and a decrease in processing times, because I think that's really adversely impacting and frankly turning many people away from this program as compared to the European programs.
All right. Julia?
So the USCIS holds periodic EB5 stakeholder meetings, and they're mostly through teleconference and usually held in Washington, D.C. And earlier this week, they held the first one in New York. And after many, many years of listening to the stakeholders conferences over the phone, I attended in person for the first time. And I was very struck by something while I was there that I had never realized when I was just doing it over the phone, is that the people at the USCIS care more than I gave them credit for. And you could feel that they were very constrained within the language of the law as well. It wasn't as arbitrary, as capricious as I think to myself while I'm driving. How can they do that? They are confined by the law and the regulations. So my wish is that if they could engage with us more, to work with us in areas where they are not confined, where the USCIS does have the discretion to work with us on policy areas, so that we can all achieve the same goal, which is the success of this project, program.
Yeah, I think Kate, Julia, you know, being lawyers as well, you would agree with me that in almost all immigration areas, there is an element of discretion available to USCIS, which they really need to be able to use more in EB5, because there are so many elements where there is the strict area of the law and strict business, and then we're dealing with real life, real people, real time stuff. So I think if we had the ability to have discretion used a little more for cases where, okay, we understand the rules are not what they should be for that particular example, but if the rules could be bent on the grounds of discretion, I think I would be happy. You agree? All right. Well, I want to thank my panel, and I want to thank you as a good non-asking question audience. Thank you. Thank you.